Senator Hosein.
Thank you very much, Mr. Vice President, for giving me the opportunity to contribute on one of, as the Attorney General said, the most important piece of legislation that has been introduced in this Parliament in this session. That is the Interception of Communications Amendment Bill 2020, which we were given a copy of last week when we last met. And Mr. Vice President, on the last occasion that we would have met in this chamber, I would have brought a motion with respect to the failure of this government to adequately deal and control the crime situation. And the government has said that this particular piece of legislation will now be a tool in its arsenal in order to deal with the crime situation. So this bill is one of the responses of the government with respect to crime and how they are going to prevent crime from occurring. But, Mr. Vice President, after I read this bill, I am certain that this bill will not alone assist the government and the law enforcement in terms of reducing crime. Because the bill can only do so much. Time after time, we would come to this Parliament and we would hear the narrative of the government, give them a fighting chance. Let us give the police a fighting chance. Mr. Vice President, this is about the 10th chance we have given this government in order to fight crime, and they have failed. And as the Minister of National Security had said, it is too late now. It is really too late. Because if you have all of this legislation without proper implementation, then it amounts to nothing, absolutely nothing. And I wanted to look at how this legislation had worked prior to its time being amended. So I was able to get my hands on a copy of the last annual report with respect to the Interception of Communication Act. And under the law, under the Parent Act, this was one of the accountability measures that has been put in place in order for some level of accountability with respect to the Parliament. And Mr. Vice President, I looked at the 2016 annual report for the period January 2016 to December 2016, prepared by the Minister of National Security, dated the 23rd of April 2017. Now, what was strange in this report is that I saw that the Minister of National Security, then Major General Edmund Dillon, MP, said that the report was statutorily due in 2016 by his predecessor. But, Mr. Vice President, when last I checked, they were in fact in power in 2016, and therefore he was the person responsible for the preparation of this report. So that is one of the issues that I had flagged with respect to why would the minister say that his predecessor was responsible when he in fact was the minister responsible for the laying of this report. So I looked at the back of the report where there are tables, Mr. Vice President. And in these tables, there are certain stipulations which must be complied with regards to the Parent Act. And the Commissioner of Police for the year 2016, the calendar year 2016, applied for 36 warrants for interception. And they were granted all 36. And there were 144,911 interceptions for speech through the SSA. Data, there was 23,084 through the SSA, and data 4 by service providers. So that is the amount of interceptions for the year 2016 by the Commissioner of Police. Commissioner of Police being one of the authorized officers under the Act. So let us look at what came out of this. So the offenses in respect of which warrants were granted, specifying the number of warrants given in respect of each of those offenses. So out of all of those interceptions, it led to 14 drug trafficking offenses, possession of firearm and ammunition 2, money laundering 10, and murder 3. The number of persons who have been arrested, 5. and there's one pending criminal proceedings where the intercepted communication is to be adduced in evidence, there have been 0 convictions as the proceedings are pending before the court. There are 35 criminal investigations. So that is what the interception of communication gave us in 2016 for the Commissioner of Police. Let us look at the SSA, because the Director of SSA is another authorized body under this particular legislation in order to intercept communication. He applied for 0 warrants, but they were able to intercept 283,418 speech, and they were able to intercept 70,162 data, all for the Commissioner of Police. Now, Mr. Vice President, you see this large, high number of interceptions leading to very small amounts of investigation charges and matters before the court. So one has to wonder whether or not, and Senator Sobers raised the point, whether or not persons are being intercepted in this country and their communication for other reasons. Because this is over 500,000 interceptions in 1 year, leading to how many? 5 arrests. So one has to wonder, Mr. Vice President, what is the basis for all of this interception? Now, another issue I would like to raise is an issue where the media is involved. Because oftentimes you would see investigative journalists having pieces in the print media, sometimes on television, where they would interview persons who may be of interest and who may be in the prisons who give information. Now, all of these persons will be captured by this legislation. Further, they would now have to reveal their journalistic sources because the data and the communication will, in fact, be intercepted. And the Minister of National Security indicated that we are blowing dog whistles. Well, Mr. Vice President, we must remember the genesis of this particular legislation. Because in 2010, when this legislation was introduced in Trinidad and Tobago, you would remember it came on the heels of an abuse of a government with respect to intelligence agencies in this country. They were spying on private citizens, on judges, on politicians, even a comedian. The president was being spied on. Steps had to be taken in order to regulate a particular government with respect to abusing its power to intercept communication between private citizens in this country.
Six, Mr. Vice President, there was certainly no law in place, and it was bought under the UNC Pandey regime, the interception suites. I object.
Okay, allow me to rule. All right, member, just be careful along the lines that you're going and the inferences that you're making. Continue.
Thank you very much, Mr. Vice President. Those are matters of public record, and I will just leave that right there, Mr. Vice President.
Everybody knows about it.
Those are matters of public record. Now, you come with this particular piece of legislation to further invade the rights and the privacy of individuals in this country. But there's one particular piece of legislation that was passed in 2011 in this country, called the Data Protection Act. Why has not that act been fully proclaimed in order to protect the data and the information and the private information of citizens of this country? But you rather bring legislation now to further intrude and invade into persons' privacy. 9 years have passed, and that legislation is still not proclaimed. You have not appointed the director and the commissioner of data, the commissioner under the Data Protection Act. You have not appointed him, but you laid this bill last week and come this week to debate it to invade in persons' rights. That is what you do in this country. That is the modus operandi of this government. Instead of being the guardian of the democracy and protecting citizens' rights, they come here with bill after bill requiring 3/5 majority to invade into your constitutional rights and freedoms in this country. Mr. Vice President, you would understand, all of us recently in December last year would have passed a particular piece of legislation in this Parliament called the Miscellaneous Provisions Law Enforcement Officers Act. A specific offense was created there, Mr. Vice President, for prohibited items. And prohibited items include, one, a telephone. The offense that is created is that if a person is found in possession of a prohibited article inside a prison and does not have the express authorization of the Commissioner of Prisons to have the prohibited item in a prison, he commits an offense. It's punishable by summary conviction for $150,000 and to 5 years imprisonment, or on indictment to $300,000 and 7 years imprisonment. So you create an offense that it is illegal to have cell phones in a prison, but today you come in this Parliament 2 months later to say, well, we are not going to deal with the cell phone problems in the prison, we are going to intercept the communication from that. I have no idea, Mr. Vice President, where in this country or where in this world you use illegal items to collect evidence. Because that is what you're doing, you know. When the law enforcement intercept all of this communication coming out of those lines, Mr. Vice President, you think that they would want to take out the cell phones from prisons? You really think that law enforcement will want to take out cell phones from the prison if they're getting intelligence? So what you are doing is that you are encouraging a cell phone problem in the prison. And now, under this particular piece of legislation, you remove the requirement to get a warrant. So you have to get no warrant, and that evidence is going to be admitted in a criminal trial against you. Mr. Vice President, that is the height of insanity in this country. Legislative insanity. You have all of the interception. Look at what happened in Gulfview recently. How many homes were raided because of intelligence and interception? You had the carnival plot that the Minister of National Security spoke of that ended up in blunders. You had recently 3 men walking free because the state did not want to disclose that one of the persons fabricated evidence against an ex-person. And we must never forget in this country, when this Parliament was tarnished by something called Emailgate. Emailgate was emails. This interception, they are going to intercept your emails, Mr. Vice President. That was abuse to the highest level in this country. And if they can do it to sitting ministers and a prime minister, imagine what they can do to ordinary citizens of this country. But I want to understand what really is the mischief in this law. What is the mischief? What if you have all of this interception taking place? You have persons being charged. What is the mischief? Why is there an issue with respect to the intelligence? Why are you now going to use unwarranted communication to be used against persons in a criminal trial? So they will get the evidence, charge persons, they'll start to prosecute, and when they end up in the court, the matter stuck there for years. You fail to fix the institutions in which this intelligence will be used. You fail to fix the judiciary. The DPP office is still in a mess. You didn't resource the police. You dismantle the NOC and put it in some watered-down agency right now. Mr. Vice President, we are not on this side going to stand up and allow enshrined constitutional rights to be limited and evaded because of the incompetence of a regime. We are not going to do that because every one of us in here took an oath to uphold the Constitution and the law in this country. We took that oath. Mr. Vice President, the Attorney General, he spoke this morning about assassinations up till this morning, that he has intelligence about assassinations. Those are things that fear-mongering, Mr. Vice President. Why are you fear-mongering to entice the population that there's an issue with respect that we must pass this bill tonight, that the opposition must support this, but persons must read the entire bill. This entire thing does not deal with prison alone, you know. This is a very overreaching piece of legislation, you know. This deals with criminal proceedings, you know. All criminal proceedings, Mr. Vice President. Under very important pieces of legislation. Mr. Vice President, when you see that, in particular, the definition section of the bill, which I get to, is that it says that the bill applies to criminal proceedings. It will apply to proceedings under the POCA, the Proceeds of Crime Act. It would apply to proceedings under the Extradition Act, under the Anti-Terrorism Act, and under the Civil Asset Forfeiture, Recovery and Management Unexplained Wealth Act. Those were all passed in this Parliament. But what it says is that it will only applies to unless the trial has commenced and is in progress. So what does that mean? Once a trial under this particular piece of legislation starts, you can't use the intercepted data. The prosecution cannot use it. However, if a trial has not started, you are allowed to use the information. Let's put this in context. In Trinidad and Tobago, there are hundreds of cases before the assizes, cases that would have gone through the preliminary inquiry stage. And therefore, the prosecution would have led all of the evidence so that the defense knows that the case he has to meet when he gets to the assizes. Fine, that is the procedure. Now you have a situation where information is now intercepted, fresh evidence. They can intercept your current and monitor your current calls, your emails, text messages. But they can also access your stored data. So now it can place the defense in a very unfavorable position, because all the prosecution needs to do at the trial, before the trial commences, is make a fresh evidence application. Because at that time, when the evidence was led in the preliminary inquiry, the evidence could not be available because you did not have the procedure in order to capture the evidence. But now you have the evidence at your disposal, so therefore you can make that fresh evidence application and admit that to trial. Now that could lead the prosecution, give the prosecution an unfair advantage in the criminal assizes. So that is one point with respect to the timing of this particular legislation. Now, I also wanted to raise, Mr. Vice President, the other issue with respect to this warrant and the evidence being allowed to be entered with the warrant. And I want to spend some time on that issue because that is very fundamental to this particular piece of legislation. That is, I would consider, the crux of the legislation. And that, Mr. Vice President, on the face of it, it does not only apply to evidence from the prison. So if I can explain it, under the current law, you have two modes of interception. You intercept using a warrant. You go to the High Court, the authorized officer, he makes an ex parte application, a warrant is granted, and he's allowed to intercept via that warrant. That evidence will ultimately be admissible in court. The second method is that any one of the three authorized officers, the director of the SSA, the commissioner of police, or the chief of defense staff, will be able to intercept communication, but that communication that is intercepted will not be admissible as evidence. It can be used as evidence in order to obtain a warrant. And there are various grounds under which they can go under. So if you would permit me, Mr. Vice President, I want to explore some of those grounds where they would be able to get So, Mr. Vice President, under the warrant, you apply under Section 8 or Section 11 in order to get that particular warrant, and there are certain grounds you have to meet. Now, the other grounds that you have to, just find the bill. The other grounds that you have to meet in order to intercept the communication has to deal with matters of national security, it deals with also where you consent to the communication, and it also deals with, right, this is it here, at section 6. In the interest of national security, for the prevention and detection of an offense for which the penalty on conviction is imprisonment for 10 years, for the purpose of safeguarding the economic well-being of the state, for the effect of giving international mutual assistance agreement, or you have reasonable grounds for believing that the person to whom or by whom the communication is transmitted consents to the interception. The communication is intercepted as an ordinary incident in the course of employment of the provision of telecommunication services. The communication is not a private communication. The communication is a stored communication and is acquired in accordance with under any other law, and the interception is of a communication transmitted by a private telecommunications network and is done by a person who has a right to control the operation or use of the network or the express or implied consent of the persons. So those are the grounds under which you can intercept information. Now, the amendment is being made for this information or this evidence or this communication to be admitted into court, but the leave of the court must be granted in those circumstances. But, Mr. Vice President, one would wonder why it is that you are trying to get around going for a warrant. Because that is what it does. It now allows you to get the data, the communication data, without going for a warrant. Now, to satisfy a judge to grant a warrant under this legislation, it's a very high threshold. Because when the judge considers the application for a warrant, there are various grounds he has to consider. He considers the duration. There are so many factors. I will want to go through some with you, Mr. Vice President. And those factors are very important to show a level of security and safeguard to the right of privacy, because this is a serious intrusion into your right to privacy. So, Mr. Vice President, the judge he must satisfy himself that he shall not issue a warrant unless he's satisfied that the warrant is necessary. Very strong language, that the warrant is necessary in the interest of national security, or for the prevention or detection of an offense, or that the information obtained from the interception is likely to assist with an investigation. It's no willy-nilly that you sit down and you just go and intercept because, I know him, but I really like him, so I'll take his data. You must satisfy the court of very serious factors. One of the other things you must satisfy the judge of, which I find is very important, is that there are other investigative procedures that they can use. So interception really is of last resort. You must exercise, you must exhaust all of those other options before you come to the judge and say, I want a warrant for interception. And Mr. Vice President, would you know that this particular piece of legislation is now actually removing that layer of security and safeguard for this data, for this information? He must also then set out on a declaration. He must give a declaration indicating various particulars, his name, the facts or allegation giving rise to the allegation, sufficient information for the judge to issue the warrant, the period for which the warrant is requested, the grounds under which he requested the warrant. And Mr. Vice President, that in itself shows how important this is. Recently, there was a decision of the court, a decision by Justice Budu Singh, where he went through the history of warrants in this country. That was the case involving a judicial review matter brought by the Central Broadcasting Services Limited against the Commissioner of Police. That was the case where a search warrant was executed on the premises of Mr. Satmaraj, now deceased. And there was a judicial review application for the Commissioner to disclose the search warrant. And Mr. Vice President, the judge went through, in that case, a history of how important a warrant is in this country and in any democratic state. And what we see now is that there has been an intrusion into entire safeguard of the necessity of a warrant. But what frightens me the most, Mr. Vice President, is that with a warrant, you are satisfied that it's for a particular period. Now, there's going to be indefinite interception of your information that can be admissible in court. Now, that is an extremely worrying circumstance because as the evidence you intercept from now until forever, that all of that is going into, that can be admitted into evidence. Unlike when you have a warrant, you have a specific period in which you monitor and intercept. And that is another safeguard that was removed, Mr. Vice President. There are other matters with respect to the warrant where the judge will have to consider whether or not the evidence will be admitted through his leave in terms of whether or not there was any inducement, the reliability of the information, the method, and whether or not it's protected by legal professional privilege. Now, what was also concerning to me, Mr. Vice President, is that now, when you look at the situations where there's actually a warrant, there's now a provision in the bill where the warrant becomes non-disclosable to the defense. So they don't have an opportunity to see the warrant, even a redacted copy of the warrant. Admittedly, it may have some sensitive information, but you don't get a copy of the warrant. What is sufficient is that the witness comes and says that I got a warrant, and that's it. Your cross-examination is also limited. Again, you place the defense in a very unfair position. You're whittling away at his right to a fair trial. Now, there's a next issue that I really want to deal with, Mr. Vice President, and that is one of the most troubling aspects of this entire legislation. And I'm sure that every senator who read that particular piece of the bill, which is Clause 16, which deals with the advocates, the special advocates, they would have had some serious issues with that, Mr. Vice President. Because when you look at the special advocates under the bill, it now, and it's so obscene, I would say, Mr. Vice President, that we are in a democratic society. We are in a democratic society. It's enshrined in our Constitution. And you now want to tell a person that they are an accused person before the court, but you must not be present for your trial, and your lawyer must also not be present. That the court is now going to appoint someone called a special advocate to seek your interests. You don't know who that person is. You are not paying him, so he has no retainer with you. The bill doesn't specify how much years call he needs to be. The bill does not specify whether or not he needs to have experience. Who knows that somebody may be appointed a special advocate who is a conveyancer and knows nothing about criminal law? Mr. Vice President, so you have such a big lacuna with respect to this particular provision. But this goes to the heart of the Constitution. This goes to the heart of a democratic society. This goes to the heart of a dictatorship, Mr. Vice President. This is what it does. This particular piece of legislation here is where they model it after England. Mr. Vice President, sadly, our courts do not function like England. England has a different society from Trinidad and Tobago, Mr. Vice President. While we may model laws after them, we must look at our own local circumstances. Even the Privy Council in certain decisions will remit matters for us to tell us, you must consider it having regard to your own circumstances. Now, Mr. Vice President, this particular clause, I could never, ever agree to it. It's an absurd, unconstitutional attack on democracy, Mr. Vice President. There's an article in the UK, and you know what that article called these special advocates? It called them the faces of secret justice. Secret justice. And Clause 16 is what I will term secret justice, Mr. Vice President. Because there's no public hearing. You are locked away in a room with the judge, the prosecutor, and a special advocate who you have not retained to seek your interests. Mr. Vice President, when you look at the definition of a closed proceedings where these special advocates will be appointed, you do not have a proper definition of what a closed proceedings is. Under the Criminal and Security Act 2013 in the UK, you see that it was very prescriptive with respect to what closed proceedings are. And interestingly enough, special advocates are mostly used in those proceedings that deal with civil matters, that involve a level of sensitive information. So I will go through a list, I will quote from parts of a report of a committee on human rights in the UK Parliament where they went through it. But I would just like to bring this in perspective, Mr. Vice President, because when you look at what special advocates had to say, because they testified, they testified in England before a joint select committee, Mr. Vice President, and they had to say that this particular provision in the UK law was in fact unfair to the accused. Because from the time, Mr. Vice President, that they received sensitive information, they said that they cannot communicate with the defense anymore. But yet you are seeking his interests. There's also ethical considerations that one must take into consideration, because as an attorney at law, you owe obligations to your client. Now, if those obligations are breached, the client has the avenue in order to seek redress from that attorney at law. If your special advocate doesn't represent you to the best of his ability, then what redress does the accused person seek, Mr. Vice President? And that is an issue that we must look at. When you look at what the special advocates are used for, I will give the context, because this is from a 7th report of the Constitutional Affairs Committee of the UK Parliament. And this came about by a case called the Chahalal case from the European Court of Human Rights, where they said that they must strike a balance between national security and protecting one's fundamental rights. But here the case is where the special advocate is really used in. In the Northern Ireland Act, for the appointment of a special advocate in respect of appeals to a specialist security tribunal operating in a field of employment and discrimination law. Under Section 5 of the Terrorism Act, for determining appeals against proscription of an organization by the Home Secretary. Under Section 70 of the Anti-Terrorism, Crime and Security Act 2001, which establishes the Pathogens Access Appeal Commission, which hears appeals of people prescribed from working with certain dangerous material. The Employment Tribunal rules a special advocate is appointed in proceedings before the tribunal from which the appellant or his representative have been excluded on national security grounds. A special advocate may represent the interests of a prisoner before the Northern Ireland Sentencing Review Commission and the Northern Ireland Life Sentence Review Commission, where the prisoner and his legal representatives are excluded from the proceedings. So you see the instances in which it's applied in the UK, but in Trinidad and Tobago, you come in to apply it to any criminal proceedings. You come in to apply it to the Extradition Act, to the Proceeds of Crime Act, to the Unexplained Wealth Bill that deprives you of your property, Mr. Vice President. That is what this government is doing, It's a chopping away, a constant chopping away of your rights and privileges in this country. Now, there's so much to say about the special advocate in terms of the role that they play, because they have two roles, which is the disclosure function and the representation function. All of that, again, is not listed in this particular piece of legislation. What will guide them? Is it that the same code of ethics in the Legal Profession Act will guide them? Because now they owe no duty to the client, but yet they protect the client's best interests. Now, that is a very blurry area, Mr. Vice President, that will lead to a lot of contention in this country. Now, that is with respect to the special advocate. And those are some of the points that I want to raise there. But, Mr. Vice President, while I was doing my research, I came across a case, and I'm quoting the name of the case, Al-Rawi and others, against the security services and others, 2011 UK SC 34. Now, that's a Supreme Court decision, and apparently the person had the same last name as our Attorney General. And it's quite ironic, Mr. Vice President, because in that case, the Al-Rawi in the UK was actually fighting against closed proceedings. And while we have Attorney General Al-Rawi in Trinidad and Tobago fighting for closed proceedings in this country. But what I wanted to quote the case for, Mr. Vice President, is because I just want to quote from a particular part of it, which says that in those cases with respect to closed proceedings, Parliament should not when Parliament is looking at legislation like that, they should always keep in mind open justice and natural justice principles. So therefore, you must balance the public
Senator, you have 5
interest-
more minutes.
Okay. You must always balance the public interest in maintaining a fair justice system with the public interest in the protection of national security. That is very important, because when you look at this particular section, this clause, you realize it's weighed on one side. It's prosecution heavy rather than defense heavy. There's no balance being struck here. You realize that this is a very unfair clause in the legislation, Mr. Vice President. And we, as an opposition, absolutely cannot support this particular clause in particular, because it is such an intrusion into someone's fundamental rights in terms of due process and the right to have an attorney at law, Mr. Vice President. And let me just give you a take on that, because there was a case in Trinidad and Tobago. That is the case of Gavin Sukram and Conrad Burrows, the Commissioner of Prisons, where in this country a prison rule that indicated that a prison officer must have sight and he must be in hearing between the attorney at law and the prisoner. That rule, Mr. Vice President, by Justice Gobin, was struck down as being unconstitutional. And what you're doing here right now is that, you know what you're doing? You're saying that you can't have communication other than using the designated line. Mr. Vice President, don't you believe that designated line is also going to be monitored? Don't you believe, why don't they put a particular clause in this bill that indicates that that communication between the prisoner and the attorney at law at the prison using the designated areas and the designated device not be monitored? When you look at the unwarranted communication also, this is what it says. The bill creates an exception from legal professional privilege evidence from being admitted into evidence. But what it doesn't say, Mr. Vice President, is that you can still intercept a telephone call, I'm talking about outside prison, between two persons, one person who's talking to his attorney at law. You know what they are saying, but at the end of the day, they cannot be admitted into court. But they know what you have said. They know what has been communicated. When Sean raised the point that in New York, from the time a person communicates with his attorney at law, the interception must stop. In this case, you can monitor, but the only thing you can do is admit it in court. And that is very dangerous, because now the defense is actually revealing the entire case, and all the client's instructions are going to be intercepted. Then you have the last clause, one of the clauses in the bill that deals with you are keeping this evidence that deals with destruction for contextual purpose. What is contextual purpose? Is it that when a letter came out from the email gate scandal that we must keep emails so that there's no contextual purpose? That is what it's for? To set up political opponents in this country, Mr. Vice President? What does contextual evidence mean in these circumstances? But I want to say, Mr. Vice President, that the Attorney General asked us to be patriotic, and we will be patriotic on this side. We will stand on the sides of the citizens. We will ensure that we protect their fundamental rights and freedoms from being intruded by this government. That is what we will do. We will drape that red, white, and black flag around us, and we will say no to this government, Mr. Vice President, when they are coming to trample and abuse the authorities of the state, Mr. Vice President, and create no confidence in the institutions that are here to protect us. And I thank you very much.
Senator Vieira.
Thank you. This legislation clarifies and will expand the state's powers in intercepting and using citizen communications, whether via phone, internet, or new media, in significant ways. I think it also softens the Parent Act by making additional safeguards and protections for citizens. This is not new law, as the Parent Act has been around since 2010, nearly a decade now. Nonetheless, because this legislation and its Parent Act impacts constitutionally enshrined rights, in particular the right of the individual to respect for his private and family life, and the right to be afforded protection against self-incrimination, it's important to weigh the pros and cons of this interception machine, ensuring as far as possible that citizens' rights are safeguarded and protected, especially those who are innocent of any wrongdoing and where collateral intrusions may occur. And that's why this bill requires a 3/5 majority. This bill upgrades law enforcement capabilities where the interception of communications is concerned by what I would say, by modifying and improving 5 gears in the machine. First, it allows for communications from prisons and prisoner transport vehicles to be intercepted and recorded. I will say more about this later, but I personally have no difficulty with this aspect of the legislation. Secondly, it provides for authorized officers to apply for a warrant to obtain and disclose stored communications from telecommunication service providers. I would call these the second and the third gears. And they may only be used in the interest of national security, for crime prevention, for detection purposes, and for investigating or detecting unauthorized intercepted communications. Again, once interceptions are made strictly in accordance with the law and the courts are effectively able to serve as a check and balance, I personally have little difficulty with this aspect of the legislation. The fourth gear of the machine concerns the special provisions relating to sensitive information and how such information should be handled. In particular, the bill makes it a serious offense for persons to intercept communication without lawful authority. Now, this prohibition of interception by unauthorized persons is extremely important, given that the state is not the only actor with machinery to spy on citizens. There are persons in the private sector, and we've heard even some criminals, who also have that capability. So the provisions relating to this gear in the machine actually guards and protects citizens from being spied upon by other citizens and against things like industrial espionage. And these provisions, in my view, are necessary given the lack of a proper privacy law in Trinidad and Tobago. The fifth gear allows and sets out the circumstances under which intercepted communications, especially those involving sensitive information, may be used in court proceedings. All told, I would say that the framers of this bill have tried their best to strike a fair balance between the interests of national security and crime prevention on the one hand, and intrusions into the privacy of citizens on the other. Now, I do have some concerns about record keeping, copying, and who may have access to interception material. But before getting to that, let me return to the interception of communications from prisons and prisoner transport vehicles. Insofar as the measures in this legislation will protect prison guards, court officials, law enforcement, and their families, I am fully in favor. We expect prison guards and law enforcement to maintain order and security in prisons. We rely on them to protect society. And for the services they render, they deserve full protection under the law. Prisoners traditionally under lock and key would pose no threat in the past, but mobile phones and their apps and their many ways of communicating now allow for death sentences, orders, and directions to be issued from behind prison walls. This must be stopped. And there's another dimension to this. In the old days, a lot of information came to the authorities via snitches, plants, informants within the prison. And no doubt this will continue. But today, the best informant will be the prisoner himself, especially where he and his confederates communicate the nefarious schemes amongst themselves. I want to point out, there is no infringement of constitutional rights here, as prisoners' rights are already curtailed under the law. While their human rights, such as the right to life, the right not to be tortured, are maintained, many of their constitutional rights are restricted. The right to liberty and freedom, the right to family life, the right to privacy. When you go and you have a client in the prison, letters and communications are read by the authorities routinely, save for those exempt under legal professional privilege. Prison visits from family members and friends take place within sight of a prison officer. There is no entitlement of being able to communicate with persons outside, save for relatives and for legal advisors. That is in nature of prison life. And the same way prisoners may not carry firearms and offensive weapons, they should not have communication devices. And if they have them, when they use those devices, law enforcement should be able to intercept and use those communications. I have no problem with that. Now, prisoners are one thing, but citizens have the right to respect for their private and family lives. And those rights should only be interfered with under carefully defined and very strictly confined circumstances. But the legislation carefully and precisely sets out the boundaries. This legislation applies only to criminal proceedings under the Proceeds of Crime Act, proceedings under the Anti-Terrorism Act, proceedings under the Extradition Act, and proceedings under the Civil Asset Recovery and Management on Unexplained Wealth Act. Further, only an authorized officer, and it is important to note that neither the Attorney General, the DPP, or ministers of government qualify as authorized officers under Section 5 of the Parent Act. Only an authorized officer can apply for an interception of communications warrant. Yet further, the authorized officer must apply for that warrant from a judge of the High Court. And before any warrant is issued, the judge must be satisfied that the requirements under Section 8 are met. Let me say what those requirements are. Specifically, the judge must be satisfied that the warrant is necessary in the interests of national security, or for the prevention or detection of an offense where there are reasonable grounds for believing that an offense has been or is about to be committed, or that the information is likely to assist in investigations, and as Senator Hosein pointed out, that other investigative procedures are unlikely to yield the critical information, that it would be in the best interest of the administration of justice to issue the warrant, and that the interception of communications to be authorized by the warrant is proportionate to what is sought to being achieved by such interception. As Senator Hosein rightly points out, a very high threshold indeed. So warrants for interception cannot and will not be granted willy-nilly. First, only a select few can apply for those warrants. And secondly, the applicant must satisfy a judge of the High Court that the criteria set out in Section 8 are met. The applicant must also make a declaration under the Statutory Declarations Act in support of the application. And even after all of that, the judge still has to be satisfied that the information cannot be obtained some other way and that the warrant is proportionate to what is sought to be achieved. Now, the bill anticipates at Clause 24 that rules to govern proceedings under the Act will be established by the Rules Committee of the Supreme Court. I expect that in those rules, and in any event within evolving case law, guidelines on proportionality will emerge. That is to say, that the proposed interception is proportionate to what is being sought. Here's the point. The court is the ultimate gatekeeper here. The legislation requires our judges to maintain the balance between, on the one hand, the rights of citizens against intrusions into their privacy or property, and on the other hand, against the need for the activity in investigations, operational or capability terms. A warrant will not be proportionate if excessive in the overall circumstances of the case. The action, if it's authorized, should bring expected benefits to the investigation or operation, and it should not be arbitrary. Again, as we have heard, if the information can be obtained by other less intrusive means, the warrant should not be granted. So interception warrants will not, they should not occur as a free-for-all or as a one-size-fits-all activity. I have full confidence in our judiciary. I have full confidence in our judges. And I expect them to judicially and judiciously weigh each and every application for an interception of communications warrant. Now, the legislation is equally concerned that intercepted communications, especially where it involves sensitive information, can only be used in court proceedings where the judge is satisfied that it is in the interest of justice to admit it. Again, the Act very carefully sets it out. In making that determination, the judge must consider all the circumstances as to how the communication was obtained, whether the accused was induced to say what he did, and any other relevant factors which might render what he said unreliable. And with a view to even further balancing the scales of justice, the legislation provides that unless the court expressly gives leave, no evidence may be adduced, nor may any questions be asked of the witness that suggests or tends to suggest the disclosure of sensitive information. Again, another set of thresholds. In weighing whether or not to grant leave, the court must be satisfied about a number of things, including the accuracy and the integrity of the intercepted communication. If and when a court determines that sensitive information may be disclosed, the judge must issue a special measure directive that closed proceedings will be utilized. And it is in these closed proceedings that we get the presence of this special advocate, someone appointed by the court to act in the interest of justice and to represent the interests of the accused. And again, whatever evidence is looking at, if it's going to be admissible, it must conform with the law of evidence. Now, it's true, we're not accustomed to having these special advocates, but you have to read about the special advocates in the context of the legislation, right? They are dealing with sensitive information in closed proceedings. That sensitive information could be things that cannot get out into the public domain, things pertaining to national security, the disclosure of identities of key people, And the role of the special advocate is very limited. He is there only to assist the court in determining whether that sensitive information should or should not be disclosed from the point of view of the accused. I've done a number of ante and pillar injunctions, and in the course of ante and pillar, we routinely use what they call an independent attorney, a supervising attorney. So for me, this is not something new. I am personally quite comfortable with the idea of a special advocate in this very limited context, especially if it's going to be a judge or someone of a very senior rank in the legal profession who understands privacy law and things of that nature. So I want to say, in my view, this legislation is as much concerned about ensuring that the rights of the citizens are not trampled upon or abused by agents of the state as it is concerned about intercepting communication in the interest of national security and crime prevention. Earlier I mentioned, though, I have some concerns. I don't know if they're going to be addressed under rules of court, under regulations, or case law. My concerns pertain to record keeping, chain of custody, and storage of intercepted material. I would like to be given assurances that these will all be handled and stored securely to minimize the risk of loss and theft. Intercepted material and all copies or extracts of intercepted material should be inaccessible to unauthorized persons. Intercepted material should only be copied to the extent necessary for the authorized purposes. The number of persons to whom any intercepted material is disclosed, the extent of disclosure, that too should be limited and kept at a bare minimum, the minimum that is necessary for the authorized purposes, and on a need-to-know basis strictly. And most importantly, I am concerned about, as I said earlier, collateral intrusion. Now, collateral intrusion pertains to the privacy of individuals who are not the subject of the intended interception. So, for example, you're talking to your doctor, you're talking to your priest, or you might be talking to a journalist. How will the material touching on these people be handled? That doesn't come out to me in the legislation. An application for an interception warrant should state whether the interception is likely to give rise to a degree of collateral intrusion. I think when they apply for the warrant, they should be able to indicate that so that the judge is aware of it. And what measures are being taken to reduce the extent of collateral intrusion. Another concern I have has to do with the requests from foreign governments for intercepted communications under the Extradition Act or an international mutual assistance agreement. Now, I can't help but think about the Trump-Biden fiasco in the Ukraine, and it makes me wonder what sort of factors would come into play under this scenario. Presumably, these extradition requests would come under the same rules and safeguards and principles that would apply domestically. But I would like to know what, if any, protocols are in place. And I would like some assurance that such requests are not granted automatically, but must be personally considered and approved by the courts.
Thank you, Honorable Senator. As the central authority with location for the law, and as you know, but for the record to assist Senator Hosein, I'll put it now, the Mutual Assistance in Criminal Matters Act, for it to be law, we have to have the treaty, and the treaty is only brought into effect by an act of Parliament by amending the umbrella law. Sorry, Senator Sobers. In that circumstance, the central authority must consider the position of assistance for mutual legal assistance as well as extradition proceedings, and there is a strict protocol on independence. Political interference is specifically debarred from consideration. There's an absolute discretion to the Attorney General as central authority to do that. And in fact, we have exercised that discretion. I have personally in my tenure on a few occasions in terms of actual cases of the type that you're referring to.
Well, the point you're making, Attorney General, and I would like to believe that this is the case, is that requests from foreign governments will not circumvent the applicable laws and procedures, and those requests will be necessary and proportionate. Now, the vast majority of citizens use our roads and highways for legitimate purposes. But there are those who abuse them. For example, by driving recklessly or driving under the influence. Some use our roads and highways in the course of committing crime. For example, drug trafficking, human trafficking, smuggling, kidnapping, and even drive-by shootings. Over the years, law enforcement has devised ways and means for policing our roads and highways in the interest of public safety and maintaining law and order. Well, our communication networks and systems are the virtual equivalent of our roads and highways. They are essential to life as we know it today. Most citizens use them for legitimate purposes. But because they can be used by bad guys, criminals and terrorists, and we have some real bad guys in this place, organized crime, terrorists, it is essential that our communication networks and highways are also policed. Such policing is necessary, but must be proportionate. Checks and balances must be in place to protect and safeguard the rights of citizens against abuse, but policing is necessary because without it, without this type of legislation, bad guys, criminals, and terrorists will have unrestricted freedom to do as they please. Yes, this bill can be fine-tuned. Yes, this bill can be improved. But I am satisfied that the legislation is necessary. I'm satisfied it has a legitimate purpose. I am satisfied that under it, the separation of powers principles will prevail. And it seeks to assure full public confidence by being proportionate. I just want to say one thing about legal professional privilege because it's come up a few times. Yes, legal professional privilege is a substantive legal right, and it's not the right of the lawyer, it is the right of the client. But legal professional privilege can be lost. Communications are protected when you're obtaining legal advice or for use in actual pending or anticipated legal proceedings. But if you have documents subject to legal professional privilege, where those documents are being used for the purpose of committing criminal activity or fraud, you could lose the privilege. And again, it's not every conversation, it's not everything you have with an attorney that constitutes legal professional privilege. Privilege only attaches where the requirements of legal privilege are met, not just because a document is sent to a lawyer. If I have a client who is in the prison, I could tell you I certainly will not be taking any calls from him if I suspect it to be coming from an unauthorized phone. There is a procedure, there's a protocol for taking instructions from clients in a prison. And with those few words, Madam President, I thank you.
Senator Teemal.
Thank you, Madam President, for the opportunity to contribute on debate of this particular bill. Madam President, I think undoubtedly in the crafting of the Act, the Parent Act in the year 2010, and the need for such an act, one of the major factors would have been the rapid change in communications technology, overall technology, particularly communications technology. and the utilization of technology by criminals and criminal elements for the furtherance of their business. And within that 2010 Act, other than the warranted interception of communications, a significant part was the non-warranted interception of communications by the designated authorized officer. And clearly, at that time, in the crafting of that 2010 legislation, to me the intent was to be used, that piece of this non-warranted interception of communications, the intent was really a means of detecting and preventing crime, rather than prosecuting it. And with these amendments that are here before us today in this bill, Madam President, we can see a marked shift to use non-warranted interception of communications as an evidentiary tool. And in the context of the situation that our country finds ourselves in, Madam President, I can understand the shift because, as I said before, sophistication and the use of technology, our criminal elements seem to be fairly well advanced in that regard. Madam President, thus far, in the presentations, a lot of emphasis has been placed on prisons and prisoners and illegal communications from prisoners through the use of illegal devices or non-authorized devices. But Section 4 of the Act that is before us also, other than criminal proceedings as mentioned in Section 4A and B, proceedings under the Proceeds of Crime Act and the Extradition Act, we are dealing also, and we need to remind ourselves under this Act, we are dealing with proceedings under the Anti-Terrorism Act and proceedings under the Civil Asset Recovery and Management and Unexplained Wealth Act. And as such, we have to see this proposed legislation in the context also of the significant impact that it can have on white-collar crime and organized crime. Madam President, I would like to put Section 15C. And it comes back again to my point about the non-warranted interception of communications or non-warranted interception evidence. And just to propose for consideration to the Attorney General, whereas C2B, contents of a communication that is obtained by interception permitted by Section 62B and 62H, or pursuant to Section 6B, it shall be admissible in evidence in any proceedings where the judge is satisfied that it would be in the interest of justice to so admit it. And looking at C Section 2A, the contents of a communication obtained by interception under Section 62C, D, E, F, or G it says that shall be admissible as evidence in any proceedings. But Madam President, 62C, D, E, F, and G are also falls within the category of non-warranted communications. And my concern is, why not submit those aspects of intercepted communications to the same proceedings as Section 2B, where it shall be admissible in evidence in any proceedings where a judge is satisfied.
Much obliged, Senator. Insofar as this debate will carry over, as we indicated earlier, thank you for giving way to answer this. The answer is that when you read those sections of Section 6.2, they have express consent already provided to them. So there's not a circumstance where the user would ever be in a position that it was private. So the Section 6 separation between Section 6.2b and Section 6.2h, those are the circumstances where they would never know that they were being intercepted. The others referred to where there's non-judicial oversight are a carryover from the old law, and specifically because there's consent already provided for the interception by the use of the public network or private network.
Okay, thank you, AG. But although it's by consent, it's also not by warrant. And that is what my concern is, whether such evidence, even though it's by consent, in terms of a trial, that it could be contested in a manner that would be, would work against the prosecution.
Thanks again, Senator. Specifically, the clothing of confidence is destroyed by something being in the public domain with consent. So, for instance, when you call a Scotiabank hotline and they say your call may be monitored for consistency, etc., or where you're made aware that the thing is going to be intercepted, you are already in an environment where you could have said that you didn't want to participate in the conversation, but you still went ahead knowing that it was actually intercepted by those who were listening. So there's no requirement, because there's no private issue or self-incrimination issue, because you've already agreed to participate in that environment.
Thank you for that clarification, AG. I would like to just refer to Section 10. 10B, where it says in subsection 4, by inserting the word furnish the words at their own cost, such. In piloting the bill, the AG did refer to this and alluded to that telecommunication providers are obligated under the Telecommunications Act, in case of matters of national security, to bear this cost. I understand the concern that it could be a very costly exercise for the state in having to provide cost. But
thank you so much, Honorable Senator. Last time, I promise. It's expensive for the state because the state has to now acquire technology equal to that they're intercepting. So B-Mobile, TSTT's environment, Digicel, they have the capacity at little or no cost at all, because it's their system, to give you the intercept. What they do is they tell you, you come and upgrade to several $1 million, meet our system, then we'll give you access. What we're doing is actually we're getting a very negligible cost from them, because it costs them, relatively speaking, absolutely nothing to give it to you. It's only expensive where they tell you, no, you've got to upgrade everything that you have, and then you can have access. So it's avoiding millions of dollars of costs for the state instead.
okay, thank you, AG. That was just also out of concern for the private telecommunication providers, because in such an instance, private telecommunication providers have to account to their shareholders. And any exercise that they are engaged in of this nature, if there is significant cost, to the private telecommunication providers, then it would be of concern to that entity. In such a situation, I would suggest in such a situation that post-investigation, whether that service provider could present a claim of cost for consideration. And with those observations and comments, Madam President, I thank you.
Madam President, I now beg to move that the Senate do now adjourn to a date to be fixed.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Obika.
Thank you, Madam President. The matter which I seek to raise is the failure of the government to take steps to secure a permanent site for the Fanny Village Government Primary School in Point Fortin. Now, Madam President, it brings me no pleasure in my third year as a member of the Senate to bring for a third time this matter, which means that each year that I raise this specific matter, whether it be via questions on notice or via matters on the motion for the adjournment of the Senate, that this government has failed. This Minister of Education has failed to fulfill their obligations to the children of Point Fortin in Fanny Village, and by extension to the children of this nation. Madam President, via my 10-minute contribution, I will speak to the history of the site, being a failed PNM project, the resulting school closure, the inaction and neglect that has resulted, the lack of school spaces because of a general neglect by this government, by this Minister of Education, in a dereliction of duty to the children in Point Fortin by keeping schools closed. And of course, I will demonstrate very clearly that under the new regime that will come with the general election to be called this year, that the children of Point Fortin can look forward to better days ahead. Now, Madam President, I want to submit that by failing to secure this permanent site, the children of the nation, the children of Point Fortin, are under attack where education is concerned. Whether it be closing gate access, failure to open schools, removing funding for preschoolers, the atrocities are too many to mention in a 10-minute submission. So specifically, I focused this matter on the children in Point Fortin. What is the history of the site? Now, the former Minister of Education is on a record. The former Minister of Education is on a record, Dr. Tim Gopi Singh, as warning the current minister against any attempts to mislead the population in thinking that the sinking Fanny Village Government Primary School was a project of the People's Partnership Administration, when he reminded him, and this is on the Contractors Association website, that it was a failed project under the Patrick Manning administration. All right? It was ill-advised in the way it was constructed, and the contractor failed in his duty. And it was something that was left to be fixed by the People's Partnership Administration. And there were some issues with that project, significant issues with that project. There was also the issue of fire. But after 4.5 years of having moved the children because of this issue of the fire to the community center, I hope that the government would come with a resolution to this matter. But here we are in 2020. Months away, I'm hearing the Minister of Trade, Madam President, asking what happened, but they have had 4.5 years. What has this government done? They have failed the children of Point Fortin. Now, Madam President, what is the result of the school closure? The school is being housed in a community center, which is less than ideal. It is less than ideal. I've spoken to the principal. I've spoken to members of staff. It is less than ideal. In fact, What is the main issue with not giving the students in Fanny Village that permanent site? Is the people of Point Fortin are being denied of the premier community center, which is the Fanny Village Community Center. I know this because I myself contested and won the opportunity to represent Point Fortin in the arena of spoken word at the Fanny Village Community Center in 2012. Fanny Village Community Center is used for weddings. It was used for community development activities by persons in Fanny Village, TNA Road, Warden Road, Point Ligua, as far as Captiville, self-help. And, Madam President, do you know why that is the case? It is because the PNM-controlled Point Fortin borough failed after decades to restore Point Fortin Civic Center. So as a result of that, we have no community center in Fanny Village. And Point Fortin is suffering from inaction and neglect. Madam President, I want to speak to the main impact on this, which is the lack of school spaces. Every year I've come to speak because the members of Parliament from the other side who hail from Point Fortin fail to speak at the level of cabinet, because you have a Minister of Trade, we have a Minister of Sports now, Tourism, now, and we have a Minister of Housing, all of whom hail from Point Fortin. Member Randall Mitchell then is also a Point Fortin person. But, Madam President, nothing for education. What did the Minister of Trade said, what did we do? We built. The past administration gifted this government the Chatham Government Primary School. 90% complete. After 4.5 years, nothing. The Egypt Government Primary School absorbed the shortage of school spaces, a school built by the People's Partnership Government. All this government had to do was get a permanent site, and I'm hearing the din from the Minister in the Ministry of Finance, a permanent site, Madam President, for the Fanny Village Government Primary School, so they can absorb the extra students. So what is the result? What is the legacy of this PNM administration in Point Fortin? You have children who deserve to be in primary school as a right, being kept home, Madam President. They are being kept home. It's a choking situation in Point Fortin. So you have joblessness with the closure of Trinma and Petrotrin. And now you have parents not being able to send their children to school. Imagine the indignity. And I hope the Minister of Education will not come here to say anything else, but that funds have been earmarked, they have been allocated, and that they will be spent on a particular site, and give us the timeline. Give us the timeline so we can hold their feet over the coals come Judgment Day when the election is called. Madam President, can you tell me how much more time I have?
5.
Sorry, I couldn't hear you.
We finish at 6:35.
Thank you very much. The people of Point Fortin are not laughing with you all, you know. The people of Point Fortin are very upset. So, Madam President, what is the legacy? They asked, what did we do? We created E-Tech Park. We gifted them that to create jobs. The Point Fortin Highway, I have heard that has been in train since 1962. Is a Kamla Prasad Bisesa government did that. The Point Fortin Hospital, similarly. The Chatham Government Primary School, the ECC Center in Southern Gardens, which is housing the Chatham Government Primary Schoolers, which is preventing a firestorm from occurring. Education is the ticket out, but under this PNM government, they have closed down the NAC campus in Point Fortin. What are the plans, Madam President, for education in Point Fortin? Under this government, the plan is neglect. Fanny Village Government Primary School is the picture of PNM neglect in Point Fortin. And only when the people of Trinidad and Tobago have the opportunity to go to the polls, they will have the benefit of a government for the people, led by Kamla Prasad Bisesai. Thank you.
Minister of Education.
Thank you very much, Madam President. I have been frequenting this House on many occasions, mainly to answer questions and to respond to some statements that have been made by members on the opposite side. But, Madam President, this evening, it gives me great pleasure, perhaps the greatest of pleasure, to respond to Senator Obika. Because listening to him, all I can describe his presentation as a monstrous alarm of cacophony. Madam President, he shouted, he barked, and he said nothing. All he did was make a lot of noise. Madam Speaker, he started off by saying he's going to give a history of the site. Senator Obika has failed miserably as a historian because he said nothing about the history of the site. All he spoke about, he went rambling about what the PNM government has not done, and so on, without providing one iota of evidence. Madam Speaker, he speaks about a shortage of school places. Madam President, I ask Senator Obika, instead of making such wild statements, provide the evidence. What is the evidence you have that there is a shortage of school places in that school or in that area? You did not share that with us this afternoon. It just shows how vacuous your contribution has been. He tried to introduce other aspects of the argument by saying that the NEC campus has been closed down. Madam President, I have said on many occasions that the reason why the NEC campus has been discontinued is because of poor registration. And if you had known that, when registrations were opened, there were only 2 persons who had registered for those courses. Only 2 persons. If you had done your homework, you would have known better. And as a former teacher, I would have put you in detention for 1 week. For 1 week. Madam Speaker, construction work on the new Fanny Village Government Primary School started in 2008 and has achieved an overall completion of approximately 58% by October 2015, when the site activity was suspended due to several months of delayed payment to the contractor. It was suspended in 2015 due to several months of delayed payments to the contractor. I asked the question, who was in office in 2015 at that time? Yes. It can be gleaned from what was just said that the permanent site, and I'm stressing a permanent site for this school, has existed for some time. And therefore I can't understand where Senator Obika got his information. I'm told, but he got it from Senator Mark. I could understand that. I could therefore understand the erroneous information, because, as you know, at this afternoon, I had to put Senator Mark straight. You know that. Members of this House would know that. So I would suggest, Senator Obika, that you get your facts straight. A permanent site for this school has been in existence for quite some time, and therefore there's no failure on the part of this government of securing a site for this school. This permanent site is the same site on Dam Road. I'm sure you are aware of Dam Road, the same site on Dam Road on which the old school functioned before it was gutted by fire. The new school has been constructed on the same site, albeit on a different section of the site, but on the same site. Madam President, the resumption, and this is what Senator Baker wanted to hear, and I'll give him the pleasure of listening to me. The resumption and completion of construction of the new school is one of the Ministry of Education's priority projects. It is one of our priority projects. Financing has been secured and outstanding payments and other issues are currently being resolved so that works can be recommenced in the very near future. Thank you very much.
Senator Mark.
Madam President, the matter I wish to bring to your attention is the failure of the government to take decisive action to halt the award of state contracts to gang leaders and other criminal elements located in Port of Spain and western areas of our country. Madam President, I want to refer you and this Honorable Senate to an article in Wednesday, July the 17th, Trinidad Guardian, entitled $6 Million Men. And in this article, we were informed by Mark Bassant that a special branch report revealed that 2 PNM linked corporations were involved in the issuance of state contracts to gangsters in Port of Spain and in Diego Martin. Madam President, the names of the individuals are given in this article. I would not provide them to you. I'll leave that for the records because it's there publicly. What I would say, Madam President, is that a total of $6 million would have been paid out by these 2 corporations in Port of Spain and Diego Martin to several gang leaders. And Madam President, this took place since the PNM came into office in September of 2015 and continues up to 2019. This is the same hypocritical PNM government, through their various spokesmen, will try to tell this country that the opposition are in league with criminals. But here it is, Madam President, there is evidence to show, and no one has been able to deny it, that the People's National Movement, through 2 controlled PNM corporations, have been feeding gangsters in this country. And Madam President, you know what is very important about this one? When they ask certain members of Parliament from Diego Martin, whether it was MP Darrell Smith, the Honourable Member for Diego Martin Northeast, Carmen Butt, Minister of Finance, and the Member for Port of Spain North St. Anne's West, every one of them disclaim ownership. They don't know nothing. They saw nothing. They awarded nothing. They are aware of nothing. That is how they behave, Madam President. But the reality is that the police commissioner has called them to book and has called them to account. And he has asked the PNM government, Madam President, to sit with the TTPS as well as special branch so that they can assist these PNM corporations in vetting state awarded contracts before they are in fact issued to these shady characters. Madam President, the police commissioner has been saying that it is difficult for the police to provide safety and security for our country when the state continues to facilitate major contracts for gang members. Madam President, no one can argue that the bloodshed, the escalation in gang violence, in criminality in this country, you have to associate it with the PNM. They have been there for 4.5 years. They came in with no plans. They leave in with no plans. That is the history of the PNM. And they come in their dying moments to see if they can guide the country. So, Madam President, I would like that the government needs to come clean. Don't do like Shaggy and say it's not me. Don't blame me. Don't blame me, it's not me. The Prime Minister is saying one thing, Madam President. Then you have the Minister of National Security saying something else. So they are all giving different answers. But no one is getting down to the real truth, Madam President. So the Commissioner of Police, Madam President, has called on the government to work with him to take measures. The Commissioner of Police, Madam President, is saying, how can you expect the Commissioner of Police and the TTPS to bring a halt, to mitigate and to reduce the level of crime and violence in our country when the government of Trinidad and Tobago continues to fuel crime and criminality by issuing and awarding contracts to shady characters, Madam President. And I raise this matter today because the government has to account. This hypocrisy must stop. We have to unmask the PNM for what the PNM is, Madam President. They talk from both sides of their mouth. And they are involved, Madam President. I didn't say so, Madam President. It is in a special report issued by the special branch. It was in the newspapers, and not a single member of the government has denied that special branch report as we speak. So, Madam President, I have raised this matter this evening to call on the government to indicate to the people of Trinidad and Tobago what measures have they taken, what measures are they taking to work with the Trinidad and Tobago Police Service to bring about a massive reduction in this particular activity that is causing headache for the police service in Trinidad and Tobago. And Madam President, it may not just be happening in this place called Diego Martin or in Port of Spain. It might be happening in every PNM corporation today. And that is why we have to really deal with this matter and confront it, Madam President, with the kind of ferocity that is required. We need to deal with this matter. Madam President, it is alarming that when you look at, for instance, between 2015 and 2018, one gang leader obtained some $2 million in contracts from the Diego Martin Regional Corporation that is controlled by the People's National Movement. Madam President, another one in the same area between 2016 to 2018 received contracts amounting to $1.1 million. Madam President, In Port of Spain, Madam President, a gang leader, alias XY, whatever that is, AW, he got he or she, a total value in contracts of $404,000. Another one operating out of...
Senator Mark, your time is up.
Yes, thank you very much, Madam
Minister of
President.
Agriculture, Land and Fisheries.
Madam President, I could say so many things in response to my friend, but he seems in his motion to be preoccupied with the notion of state contracts and criminals being in the Port of Spain area, as he says in the motion, Port of Spain and western area. But you do have to work too hard to remember. And my friend Senator Mark relies on the newspaper. Now, he refers to us, the newspaper has referred to a special branch report that we've not seen, that he's not presented any evidence of contracts to criminals. He's read bits and pieces of a newspaper report. I find it very difficult to deal with gossip. I prefer to deal with the facts, Madam President. I prefer to deal with the facts. So let us talk about his comments, Senator Mark's comments that he's going to unmask the PNM. Well, in live sport, they weren't even wearing masks. And this is no hearsay from Mark Bassant and a special branch report that we never saw. This is a statement by Prime Minister at the time, Kamla Persad Bissessa, at the sitting of the House of Representatives on July 25th, 2014. And it deals with the audit report into live sport. And these are the findings of the audit report, Madam President. And I quote, "The review as contained in the report has revealed a number of discrepancies which include procurement breaches, a deviation from the mandates of Cabinet 2, the involvement of some persons in criminal activities, 4, fraud by suppliers, 5, theft of equipment, 6, breaches of the Proceeds of Crime Act, and 7, poor control and monitoring by officers of the ministry." So the first thing I would say in response to Senator Mark is that I want to know what your government at the time was wearing when you were engaged in this level of criminal activity with criminals based on an audit report placed on the Hansard by your political leader and Prime Minister at the time. You see, you would not talk here. When you think about criminals and state contracts, you think about the East-West Corridor, Port of Spain, and so on. Why don't you tell the country about the criminals operating in the Kuva Tabaki Talparo Regional Corporation, breaking up contracts, giving contracts to employees of the corporations, giving contracts to ministers and their friends, and so on? Why don't you tell us about the criminal elements in the Mayaro Rio Claro Regional Corporation doing the same thing? It is not only gang members.
Senator Mark, Senator Amin. Senator Mark's contribution was made. Everyone listened. It is time to hear the response. Continue, Minister.
Madam President, I don't even have to refer to any minister, former minister, shaking no hand of any alleged gang leader. I don't need to do that. I am not even going to gang leaders. I'm talking about the well-fed, well-heeled, who got a Beetham wastewater contract. I've never seen somebody with a $1 billion contract award who will not, he's not even interested in being in Trinidad and collecting on his contract. We have rusted 36-inch pipeline pile up from Beetham straight down to Cali Bay, and none of you seem concerned about that. about a man with 65 companies that took a former deputy political leader of your party to court for close to $70 million, and the judgment of the court says, in the relation to the real-time litigation involving Mr. Warner, the judgment talks about half the money being paid by checks. Well, if you pay half of $70 million to a political party by checks, you pay the other half by cotton notes and coins. And if that is not criminal behavior, why are you? We are as concerned, together with the Commissioner of Police, the Minister of National Security has said on many occasions, we are as concerned with the gangs in Cuba as we are with the gangs all over, and we are concerned with the criminals with guns as we are concerned with the criminals who are well-heeled and well-fed and existing in corporations controlled by your party as they are in corporations controlled by our party. And it's about time you start facing up to your sins, starting with live sport and your political leader's statement where she said, we didn't say, that you spent $400 and something million on criminals. Thank you, Madam President.
Honorable Senators, Honorable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favor say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.